Welcome back, everyone, for the second panel discussion. This panel is equally exciting. It's going to be about competition policy and artificial intelligence. It's going to be moderated by Agustina Hermida. Agustina is a competition lawyer working currently in a fintech in Amsterdam. The panel also gained a lot from the help and insights of Guillaume Thebaudin. Agustina and fellow panelists, the floor is yours.
Thank you so much, Rosie. Thank you for your introduction, and good afternoon, everyone. I'm delighted to welcome you all to the second panel about competition policy and artificial intelligence. As Rosie said, I'll be moderating this panel, and Guillaume Thebaudin, who is a PhD student at Paris Telecom, will be supporting the panel by selecting your questions during the Q&A. We are honored to have here with us three young experts in this area that are joining the debate: Bann Beiruti, Rong, and Emilie van Hemeldonck. We would like today's debate to be as dynamic as possible, and therefore we encourage you to add your questions in the WebEx chat, and we will address these questions later during the Q&A. We will follow a similar structure to panel one. So first of all, each speaker will present their proposal on how the challenges that AI brings to competition policy should be addressed by authorities according to the relevance in the upcoming 10 years. For the past years, AI technology has challenged the field of competition policy. In fact, this disruptive technology has challenged the foundations of competition by bringing up new debates and proposing new interpretation in the area of big tech and the consideration of data power, or even testing concepts as essential as the presence of human behavior behind the algorithms. There is no doubt that these issues will become more relevant in the upcoming years, as we will see during today's debates. In this context, Bann will start by focusing on how competition authorities should examine and address those challenges. Moreover, Rong will put the focus and highlight which should be those priorities when regulating AI. And finally, Emilie will share her perspective on which are the enforcement techniques that should be addressed when talking about artificial intelligence regulation. After that, the discussion round will take place between the speakers, and it will be based around three main questions that I'll formulate to them. Lastly, and for the Q&A, we will have a similar structure to panel one. Just as a quick reminder, if you're here in the room with us, please just raise your hand so the conference assistants will be able to bring the microphone to you, and you will be able to present yourself and ask the questions. Otherwise, if you're watching us remotely, please write your questions in the WebEx chat so we can address them later. And when I say your name, you can turn on your microphone and your video, so you will ask the question by yourself. So starting with the presentations, let me introduce you our first panel today. Bann Beiruti is a trainee lawyer at Beiruti Attorneys and Counselors at Law in Jordan, and she graduated with a law degree from the University of East Anglia. Bann, the floor is yours.
Thank you, Agustina, for the introduction, and thank you, everyone, for joining with us. Talk of artificial intelligence has been in circulation since the 1950s. The fear that machines would take over our jobs is not something that's unique to the 21st century. While hopes and fears surrounding AI are not new, today's climate has changed in two ways. Firstly, there's a vast increase in computational power and practical breakthroughs in machine learning. And second, policymakers are now starting to pay attention. We have come so far as to have autonomous or driverless cars, surgical robots, AI framing current business models, and now Elon Musk's AI interfaces with the brain has provided a new and practical solution to paralysis. It is imperative that we understand how AI works and break down its risks in order to douse our fears towards it, because if from a regulatory stance our vantage point is underlined by fear, then this would cause overregulation to smother innovation. Getting the right balance between objectives is key. In order to simplify the challenges, I've classified issues of competition policy into three categories. The first I've referred to as macro competition for AI. The second is micro competition with AI. And the third is competition between AI systems. Regarding macro competition for AI, I'm talking about the global, regional, and national race for AI development. The more data an AI system has, the more accurate it is. It thrives on data accumulation and data processing. If you have 1 trillion data points, outliers are easier to identify, and distribution of data becomes clearer. This enhances predictive performance and the potential of technology and artificial intelligence. AI is able to analyze more and deeper data using deep neural networks that have many hidden layers. Of course, using large amounts of data raises privacy issues and may conflict with the GDPR. And in some respects, I believe that the GDPR may hinder or limit the potential of artificial intelligence, especially if we're looking at the competitiveness of the EU's AI development across the globe, where not everyone has similar data protection regulations. Of course, the legal treatment of AI may prove to be challenging, seeing as technologies dissolve borders and demand action in borderless areas. This may bring up a myriad of issues in relation to the extraterritorial scope of the GDPR, and this is something that we will discuss later in the discussions. Taking this further into the sphere of mergers and acquisitions, current laws prevent the formation of market concentrations that create or strengthen a dominant position, and competition authorities are generally concerned with market power. Now that we've established that data is the building block for AI power, perhaps it is more relevant to consider whether the database of a company or an undertaking can create or strengthen a dominant position, and that would eliminate sort of competition in that field. Perhaps competition authorities need to be more concerned with data power rather than market power in their decisions, as it may be the case that a merger would not cause high market concentration or market power, but it would certainly achieve high data power that supersedes any other competitor, and that on its own would serve as a barrier to entry into the market. If data power was considered, then perhaps the Google Fitbit acquisition would have been prevented. Moving on to micro-competition with AI, we must firstly acknowledge that AI is a form of disruptive technology. It alters the dynamics of every market that it operates in. And what I mean by micro-competition with AI is the scope of the market and the extent to which AI applications can substitute goods and services on the market. This is applicable to virtually all industries, from healthcare to retail to legal. And if we look at legal technology is in extremely high demand today. It mimics the role of a lawyer, it can draft agreements, it can edit agreements based on each lawyer's preferences, it can detect relevant case law, and eventually what the outcome would be is that this would reduce time and this would translate into lower costs for clients. And according to the 2020 Legal Trends report, 58% of consumers said that technology is more important to them now than before the coronavirus pandemic. One may say that the idea of adapt or perish has been accelerated by AI, and that firms may have to invest in legal tech, for instance, otherwise they're out of the market. The increase in productivity and efficiency gains from AI may deem the adoption of AI as a condition precedent to entry into any market. So then here we must pose a question. Could AI become a barrier to entry, and are there barriers to entry within the AI market? And accordingly, we must reduce such barriers to entry. Finally, competition between AI systems entails identifying potential harms that could arise in three forms. So the first scenario is where AI is used to implement anti-competitive agreements or strategies that are developed by humans. And this is something that I believe would arise under artificial narrow intelligence systems, for example, using pricing algorithms, and that may give risks to tacit collusion. The second scenario looks at where AI implements identifiable anti-competitive agreements or strategies that were not instructed by humans. And the third scenario is where AI coincides with a reduction in competitive intensity without any explicit evidence of anti-competitive strategies or agreements. And I think that the second and the third scenarios are probably going to be extremely prevalent in artificial general intelligence and superintelligence systems, and may even be more difficult to detect. So, in my opinion, I believe that for competition authorities to be able to keep up with such potential anti-competitive behavior, they may themselves need to adopt AI systems to detect anti-competitive behavior between AI systems. To conclude my presentation, Currently, the most available form of AI is artificial narrow intelligence. That's the very first level of AI development. And it is likely that artificial general intelligence and superintelligence are soon to follow. Some say it may take 10 years, but looking at it from this point, what is 10 years? It's relatively nothing. We need those 10 years to create and establish good law and good regulations to be able to deal with the potential harms and the potential issues that may arise with such AI development. Thank you.
Thank you so much, Bann, for sharing all these relevant points with us. And I'm sure that many of these will be addressed later during the discussion round. I would like now to introduce our second panelist. Rong is a lawyer in the competition and regulatory team at Drew and Napier in Singapore. He graduated with degrees in laws and economics from the National University of Singapore. Rong, what is your view on the interference between AI and competition policy?
Thank you, Agustina, and thank you, Bann, for the very interesting speech. It is a great privilege to be here today to talk on artificial intelligence and competition policy. And today I would like to express two ideas on the topic. First, I think that we should have a more AI-informed competition policy. And second, I think we should resist the temptation to create an AI-centric competition policy. So I think that an AI-informed competition policy means applying the existing competition principles and experiences to the new future where AI will become more central in the economy. For example, much has been discussed about the prospect of artificial intelligence enhancing or facilitating collusion, but I don't think that we should confine the conversation to that kind of anti-competitive behavior. For example, Professors Julian Nowak and Thomas Cheng have written a working paper discussing about how artificial intelligence and algorithms can enhance the likelihood of unilateral anti-competitive behavior, such as predatory pricing. To give just a gist of their thesis, they argue that with algorithms and AI, the post-exclusion scenario is that firms are able to individually target consumers with their specific preferences, engage in price discrimination, and that allows them to engage in more efficient recoupment of the cost of predatory pricing or extracting exclusionary clauses. So while those avenues of anti-competitive conduct is to a degree speculative and to a degree science fiction, I think that that does not prevent the competition regulators from at least establishing certain frameworks to prepare, to detect, and formulate a response to such anti-competitive conduct. Another area where I think competition policy can be more AI-informed is with regard to intellectual property rights. In the AI industry today, a lot of machine learning models and artificial intelligence technologies are being built on shared research and shared data. In a recent study by Huawei, where the company conducted a survey of its internal product teams, they found that of the open source datasets that the product teams wanted to use, 5 of the 6 of the most popular datasets would have involved certain degrees of IP risks because of the nature of the licenses and IP rights subsisting in those datasets. The competition community is very familiar with the legal issues and the IP issues when we deal with shared intellectual property and things that are built on shared intellectual property. We can only look at the cases of standard intellectual patents to know how fraught the area is. For example, what is going on between Apple and Qualcomm in the United States and what went on with Samsung and Motorola closer to the EU. So what we can learn from the case of SEPs is that when businesses come together and contribute their IP towards establishing something valuable, in the SEP cases, we were talking about telco standards, such as 4G, when the ultimate implementation of that thing becomes very commercially valuable, you will almost inevitably have a lot of litigation, a lot of disputes over the intellectual property rights and the licensing rights. And my fear is that if we don't clarify these issues with regard to artificial intelligence that is built on shared data and shared research today, then all that litigation that we saw in the SEP context is likely to reoccur in some form with regard to artificial intelligence. And that would be a detriment to innovation in this space. So what competition regulators can consider is coming up with certain ex-ante rules to sort out these issues. For example, and this is just a suggestion, we can have a default rule that there shall be no commercial restrictions on parties building AIs on shared data and research unless the parties expressly made a reservation to that effect. So those are just some areas where I think competition policy can be more AI-informed. So on the second idea that I want to touch on is that we should resist the creation of an AI-centric competition policy. So here's what I mean. So for example, I think that an AI-centric competition policy might presume that companies with very powerful AIs are dominant in the competition and the market power sense. Or an AI-centric competition policy might be one that treats mergers of companies with powerful AIs as generally likely to substantially lessen competition. I think that such presumptions and shortcuts would be misguided because what we actually see from the AI industry today is that the space is actually very highly dynamic, where today's most powerful and most impressive AI can actually be replaced in a matter of years just by taking a more innovative model. Another way in which an AI-centric competition policy might manifest itself is also one which views other objectives of addressing the risk of AI as its own objective. For example, an AI-centric competition policy might treat issues of privacy, bias and discrimination, and AI safety as objectives of competition policy. While those concerns, I think, are legitimate concerns, I don't think that the tools that competition authorities have, such as merger regulation tools, are dynamic enough or fast-paced enough to address those kinds of risks associated with AI. So with those two ideas today that I put before you, I thank you for listening to my opening remarks.
Thank you so much, dear Rong, for sharing these insightful contributions with us. I would like now to give the floor to our third speaker, Emilie van Hemeldonck. She studied law in Belgium, Switzerland, and competition law at King's College in London. She's currently a trainee at Linklaters here in Brussels, and she will join DigiCom very soon as a Blue Book trainee from March onwards. Emilie, the floor is yours.
Thank you, Agustina, for the kind introduction, and my thanks also to the team at DigiCom for organizing this relevant and timely conference. I feel privileged to be given a voice in this important transition. As we look to the future, we are obviously going to be part of it. And I mostly feel privileged and grateful to be able to be one of the speakers today. I'm really impressed by the panel that came before us. And we have been able to meet yesterday and today with each other. And the real privilege, I think, is to be able to learn from you. And I hope to see most of you as we go into the future. We, as part of the young generation, of course, grew up surrounded by technology. But even to us, it's apparent that companies are no longer centered around humans and human labor, but around data and AI. Companies increasingly use data and algorithms, for instance, in trading, in retail, in logistics, in price decisions. And this means, I think, that we're living in a computerized economy. And this, of course, has antitrust dimensions. And there's two antitrust consequences that I would like to highlight today. The first is, I believe that AI enables companies to engage in new ways of anti-competitive behavior. Let's take the example of a pricing algorithm, for instance. Pricing algorithms, they enable companies to automatically monitor prices of competitors in real time and then reprice. They're quite often used in hotel booking and entertainment industries, but they facilitate and enable new ways of collusion. For instance, price monitoring algorithms, they are used to detect deviations from prices that have been agreed before, so they're part of the infringement. But algorithms can also be used to implement an agreement. For instance, if companies agree to allocate a market or to set a price, then they can use a common computer system to implement this agreement that has been concluded in shady smoke doors behind closed doors. I think this brings me to the second consequence, which is detecting these new anti-competitive behaviors will be increasingly hard. And more specifically, this puts our legal framework and legal concepts under pressure. If we take the example of a pricing algorithm again, what does it mean if a company unilaterally and independently adopts a pricing algorithm? What does that mean for the requirement of intent? And what does it mean for liability, for instance? Is the company liable? Is the developer liable? Is the AI itself liable? But more specifically also, if you look at concepts that we now use in enforcement, such as market share, relevant market, market power, and the SNP test, these things in data-driven markets will have to look at differently. Not only in time, because they can evolve way faster, but also they can evolve over a longer time. The products and services are not as clear. There's also a different geographical scope. And what do we do with markets that have no prices, but that use data as a commodity? I believe, therefore, that a point can be made to embrace computational antitrust. And by that, I mean that competition authorities embrace computational techniques, such as big data, AI, machine learning, deep learning, because they can capture rich data about markets and offer a more granular and detailed analysis. And there's many beneficial parts about this, but I think the one I want to highlight most is the efficiency and reducing of burdens. For instance, if we look at evidence that has to be gathered, the scale and time can be enormous. The example of the Google shopping case, sorry. I think the Commission had to look at 5.2 terabytes of search results, which come down to 1.7 billion actual search queries. That's quite a lot to look at. And then secondly, it can also help to reduce the burden of requests for information, for instance. Now, what do I exactly mean by big data and AI and machine learning and deep learning algorithms? It all sounds very fancy, but what does it mean to adopt these tools by competition authorities? There's two examples I can give. The first is what is called automated monitoring. They those are tools that allow companies to monitor, competition authorities to monitor behavior that is conducted by humans, or in this case by algorithms. And behavior that can be looked at is easier to analyze because you don't have to open up the black box of an algorithm. You can just look at symptoms that look like there's no unilateral conduct happening. And this can be like there's unexplainable price increase, there's output restriction even though there's a high demand and the profits are high. And the second example are machine learning algorithms that can be used to spot different kinds of breaches, for instance, in consumer law. And for instance, if there's unfair prices or unfair conditions, these can stem from anti-competitive behavior. And if these algorithms are used by competition authorities, that might make it easier to detect it. So I think to summarize, my point is mainly that development in technology has grown exponentially, but this has not been met by the same development in computational enforcement tools. And I believe, therefore, that a point can be made to focus more on technology and the digitization of the market, which is why this conference is a great first start. And second, to embrace computational tools. So that concludes my presentation, and I look forward to discussing it with you in the next round.
Thank you so much, Emilie. And proceeding now with the discussion round, which is honestly my favorite part of this panel. And considering your perspective, there's actually one topic that is especially relevant and have already been mentioned by some of you. And this is the concept of data power. So my first question for you would be, is or should data power be an important consideration for AI and competition law? And if so, why would you say so?
Give an answer to that question, or let's say a response. So I think that if we are talking about all firms in the economy in general that use AI in some form or another, then my answer is actually no. I don't think that data power should be seen as a generally important consideration for the purposes of competition policy. And here's the reason why. I don't think that it is true that having a lot of data necessarily translates to the ability to create a powerful or impressive AI. And I also don't think that it is true that having a powerful AI necessarily translates to having market power in the traditional competition sense. For example, we can think about social media platforms such as Facebook and Instagram. If you asked anyone maybe 5 years ago whether or not they were dominant social media companies whose dominance were attributable to their data advantage, I think a lot of people would have said yes. But what we have seen with the entrance of other companies like TikTok in the sector is that for all the data advantages that Facebook and Instagram have, what can really threaten their market share is really a more innovative model that doesn't necessarily rely on having an existing data advantage. So I would concede that maybe for some industries, such as insurance industries, the future of competition may rely on having a very powerful AI that is trained on very accurate and complete data. But I think that focusing on data power is a generally important consideration simply because the future will be one where AI is more important, really risks forgetting or ignoring the more fundamental competition principles, such as questions of market share and market power. But more practically speaking, I think that there is an issue with talking about data power, because how do we even measure or compare the data of companies in the first place? Say in a merger between different types of firms, for example, the Facebook acquisition of WhatsApp. What we understand is that the two companies possess very different types of data about its users. So how is a competition regulator supposed to approach that question of whether or not the combination of the data between the two firms is likely to have a pro-competitive or anti-competitive effects? I think that would require a lot of forward-looking estimations and assumptions, and I don't think that most competition regulators out there are equipped to come to very certain conclusions on that. And relatedly, how do we objectively measure the data power of various companies? Do we just look at the number of consumers that they have data on? Do we look in terms of megabytes? I think that those are two key flaws with viewing mergers from a data lens, but that's just my opinion, and I'm open to hearing whether anyone else on this panel has other views.
Well, I would like to answer your question about how to measure data power, and as well as I have a different opinion on data power. I believe that data power is very important to consider with the world of artificial intelligence. I believe that firms now have the ability to have a competitive edge through extending the type, volume, and sources of data in a radical way. And the ability and method of collecting data differs from firm to firm. When we use a service for free, for example, Google or Facebook, we pay with our data. This is how we pay. These two examples in specific achieved tremendous profits just by their use of big data. Therefore, competition authorities really need to consider whether data power can create high market concentration. Now, don't take me wrong. My opinion on this matter, when we look at data power, it doesn't mean that having some access to data will mean that you have the ability to have a strong influence over the market on its own. This isn't necessarily the case, but we need to consider several things. So I think that we need to consider first the amount of data that one can accumulate, the type of such data, whether it's personal, whether it's non-personal. And this is very important because this is what facilitates personalization and profiling techniques, and these have a lot of influence as well. We need to consider whether the data is exclusive, whether there are interoperability arrangements, and we need to focus in specific on special access to data that is capable of enabling an undertaking to escape competitive pressure. Now, these things differ from one case to another. There can't be no uniform way to look at things, but it's a consideration. And it doesn't mean that we don't look at what current competition authorities look at. Market power, market shares, these are all essential, but data power should be another means that's added to look at mergers and acquisitions that pertain to the world of AI. And I believe that what we need to prioritize is two things. The first thing is data that tips the market. So an undertaking is able to hold a dominant position on the market where, for example, it uses its data power to tip the market towards its own product. And this is referred to as the reinforcing effect. And we need to look here at how platforms use network effects and corresponding lock-in effects. And secondly, we need to look at whether the data is exclusive or not. Now, not every company has the volume of data necessary to build a unique set of capabilities using neural networks. When algorithms are self-learning, the data itself becomes an asset. Data can create a competitive advantage, and if you have the best data in a competitive industry, even if everyone is applying the same techniques more or less, the best data will win. And I have an example for this. So you talk about public data sets in your opening spiel. I searched the other day public data sets, and I went and I looked at the different types of public data sets that are available. And one interesting one was related to self-driving or automated cars. These public data sets are mainly used to train AI in New York, in California. And the first thought that came to mind was, if we train this car and then bring it to Jordan, where I'm from, or to Egypt, the car will suffer from PTSD. It will not know how to operate. And so in this type of, considering this, sorry. If we consider this, the best data in the market will be the one that's most relevant, the one that has the most accurate data that's trained within the sphere of these countries. And it has happened. There are several cases where self-driving cars have run over persons, or they haven't been able to do what they were meant to do because of they were not programmed to deal in certain circumstances or atmospheres. Now, going further to the Google Fitbit case, I believe this case in specific is where we are more able to differentiate between market power and data power. And Google here, in my opinion, escaped the radar of competition authorities because there is no current consideration of data power, and not because it is difficult to look at that. And I think especially when looking at Google and Google's practices, it would be relatively easier to see the whole data power intersection, as it has been iterated by several academics that Google is practicing what is referred to as platform envelopment. And basically they acquire these different platforms and then they offer them for free. And this is how they build their data empire, by gaining data. Because again, when a service is for free, we pay with our data. Therefore, in my opinion, I do believe that it is imperative that we consider data power, and especially look at the impact that this may have on adjacent markets. When we look at mergers and acquisitions, like in Google, this interrupted the insurance industry, as Rong also said. So this is personally my opinion. What do you think, Emilie?
Bann, actually, I hear your point about how consideration of data are very important. But what I actually think about really has to do with about the balancing of enforcement costs versus the marginal benefit of focusing on data. So you did mention the Google Fitbit case, right? And I think that similar to the Facebook WhatsApp acquisition, I think that Google Fitbit really shows how difficult it is for competition regulators to analyze the outcomes of mergers of different types of companies that deal with different types of data. So Fitbit has health and fitness data, Google has search history and all other kinds of data. Just thinking out loud, with these different types of data, it is probably very hard to analyze what the consequences of the combination of such data, and it's also even harder to predict what kind of artificial intelligence models can be built on that data. Therefore, I think that even if we try to analyze the problem from a data perspective, our conclusions about the impact on competition will be very uncertain, meaning that the advantages of the exercise would probably be particularly low. And as Emilie mentioned, we would have to go through a lot of data to assess mergers from a data lens, and that means the incurring of significant costs and as well as a delay to the merger procedure process. So to conclude, while I hear your point that data is an important or rather desirable consideration, I think that given the very small benefits in terms of the uncertain outcomes that of any such an exercise would bring and the significant costs that such a analysis would entail, that's why I don't think that data should be treated as a generally important consideration.
Well, if I can just quickly jump in here, Rong, you just mentioned that a lot of data has to be assessed and gathered, and I agree. If I can just refer back to the Google Shopping case, which I mentioned before. I think a question that I would ask Bann, therefore, because she mentioned the importance of data power, is imagine instances where companies have a lot of data and have data power position. Do you believe in these situations that that these companies should be forced to get rid of certain data assets, and in other words, should they divest themselves of these data assets?
I don't believe that we should break up big tech companies and have them divest their data assets in general. We should regulate them. However, in the case that there was massive abuse of dominance, then perhaps we can resort to such a measure. However, only if it's necessary, and probably as a very, very last resort.
Well, it's interesting because I agree that it should be a solution, but I disagree that it's only be a last resort. I think that it has to be more important. For instance, if we think about the Facebook case, which was investigated by the German competition authority, was also mentioned in the first panel. I think this case illustrates that divestments of data assets can actually make a real difference in the market. Because what happened in that case is that the competition authority in Germany looked at the way Facebook collected, merged, and used data, and they said that this amounted to an abuse of dominance. And the reason for this was that users could only use Facebook if the data that they use, the data that's been gathered outside of their use of their Facebook account, was also added and assigned to their user accounts, for instance, through Instagram or WhatsApp, but also through third-party websites that had, for instance, like or share buttons. And that led to a situation where Facebook was just combining and gathering all this data and assigning it to specific user accounts. And you already mentioned it, it's a privacy issue, but it's also a competition issue, because it creates a real powerful position for Facebook, and not just to the detriment of consumers, but also to the detriment of competitors, for instance, startups that just entered the market. And I think this case illustrates that, like, the German competition authority, they eventually decided that Facebook couldn't do this anymore. They couldn't make this conditional, the use of Facebook not more conditional on this data policy. And so what it eventually came down to was an internal divestiture of Facebook data. And this brings me actually to an answer to the main question about the importance of data for AI. I think it's crucial, and especially in the debate about access to data. So I already mentioned it, but if we look at markets where there's powerful players that have a lot of data, we as users of social media, for instance, don't always know what we agree to. And it's really hard for companies that just enter the market to compete with these companies, because they don't have that much data, they don't have access to so much information. And this is of course, a competition issue, because this doesn't create a level playing field. And not just talking about access to data between companies, but also access to data for competition authorities. I mentioned already the importance of embracing computational tools. And algorithms, for instance, they need data to be able to learn and to function better. And if competition authorities don't get access to data, they cannot teach them their algorithms, and so eventually they cannot evolve with the market. So I think it's a really important issue, data, and which is going to be crucial for the future of AI and competition law.
So Emilie, I think you had a great point when you talked about data disparity between big incumbent firms and entrants. However, I just want to push back a little on the assumption that having a lot of data is necessary to compete in a future where AI is more central to the economy. So what is true, while it is true that if you want to build your own AI, you better have a lot of good data and you better have data which is accurate and complete. However, I don't necessarily think that even in a future where AI is more central to business operations, that you need to actually build your own AI models. What we see today in the AI industry is actually that there are many companies out there that are looking to sell or license their AI technologies to other firms for their use. So such off-the-shelf services exist for a variety of users currently. Text recognition, image recognition, legal work, consumer chatbots. So I think that even if the future is one where AI is more central, you don't actually need to necessarily build your own AI model to compete. And well, those are just my views on the ultimate question of whether or not data power necessarily is an important consideration in a more AI future.
Thank you so much. Thank you, Rong, for your final remarks, and thank you to the three of you for sharing your insightful comments on this topic. Continuing with the debate, as you may know, the European Commission last year proposed the very first ever legal framework for artificial intelligence, as it's known as the AI regulation. So considering this potential increase of regulation in this area, I would like to know more about your perspective on how would you balance the need for AI regulation against promoting a free market with low barriers to entry?
Okay, so I'm going to start this discussion by talking about what forms of regulation currently are in the market that may conflict with the AI development goals. So as I talk about it in my opening spiel, I talk about the GDPR. The GDPR is a rigid data protection structure that regulates the processing of personal data and automated individual decision-making, which I believe in some respects may hinder the limit the potential of AI. Now, the GDPR is very important. In my opinion, upholding privacy rights are the most important. And I don't think that this is something that's stressed enough, because when we're looking at technology, we don't really realize what is necessarily happening. So if we consider, for example, how it really works, if for example, Emilie, think of it in that way, you have someone standing outside of your door, and then you leave, and then they write on a piece of paper, oh, Emilie left. And then you ride in your car, and they're like, Emilie rode in her car. And then you stop by the grocery store, and they write down every single thing that you bought. And if there was a person standing outside every person's house in the whole entire world, then this would cause a revolution. Everyone would call it a police state, and there would be serious calls for change. But we don't realize it because it's through our technology, and we don't really understand or grapple the extent to which our data is everywhere. And I believe that in some respects, the GDPR is really good in that it regulates for that, but in some respects it doesn't go far enough, because I believe that consent on its own is not enough. What is consent? I still press I consent to giving my information, and I supposedly understand a few things about artificial intelligence because it's an obstacle in my way. A lot of people don't really understand the extent of it, and I believe that most people don't really understand the extent of it. And we need to work towards reducing the informational asymmetry and perhaps demand a change to more informed consent. Because we really do need to uphold the rights to privacy. And there may be a lot of people that have the opinion of, oh, I have nothing to hide, so what if my data's out there? But I read something once, Edward Snowden said it, and it really stuck with me. He said, if you say, I give up on my right to privacy because I have nothing to hide, then it's like saying I give up on my right to free speech because I have nothing to say. So we should really understand the extent to which our data is important. Furthermore, I want to talk about the extraterritorial scope of the GDPR. So the GDPR can extend to to processing of data by companies all over the world if they process any EU citizens' data in a way that conflicts with the GDPR. And as I understand, the fine is extremely hefty. And not every startup will be able to, for example, comply or will be able to withstand the effects of paying 10 to 20 million for breaching the GDPR. Furthermore, if we're looking at countries, because as we said, AI is something that's global, it's international. If we take the example of medical AI, so now they have these technologies that are able to diagnose, and they collect data from all over the world. And if they're collecting data from, for example, countries like Jordan, where we don't have a data protection regulation at all, and many other countries don't, then they will be able to process information, personal information, in a way that, for example, companies in the EU would not be able to. And this might make their AI systems stronger or more accurate, and they would be able to diagnose more effectively. And so this is something to consider, the competitiveness of EU's AI systems across the world. And maybe consider that companies may want to move to countries where there are no relevant data protection structures, because they would be able to process information freely. So the world really needs to get into this talk on data protection and privacy to be able to reduce such worries.
Thank you for your very impassioned defense of the rights to privacy. And I think that you really also hit the nail on the head when you said that regulation has potential negative effects on innovation within the jurisdictions to which it applies because of the additional regulatory costs. So I think that no discussion on regulation would be complete without also considering the AI Act, which Agustina mentioned. So, like you, I also actually think that the AI Act serves very important purposes for civil society. For example, it addresses serious risks such as subliminal messaging through artificial intelligence, as well as the targeting of vulnerable populations. I think that those issues are definitely serious and important, and the AI Act is very timely in that regard. I also applaud the AI Act for taking a risk-calibrated approach by differentiating between high-risk AI and low-risk AI and imposing a heavier regulatory burden on the first. However, I think that there are areas where the AI Act is imperfect, especially as regards to how it might impact innovation in the AI space. The first point is that the definitions of high-risk AI in the AI Act are actually fairly broad. So we actually talk about issues of employment, financial services, and education. And that means that whenever an AI company deals in these areas, or where it may even touch on these areas in a peripheral sense, then they will have to go through the legal regulatory assessments to determine whether or not they fall under the Act, and if they do, what they can do to comply with the Act. And I think that if the Act is implemented, that may constitute a significant regulatory burden on startups, especially in the European community. The second thing that the AI Act, I think, there was a missed opportunity with regard to the AI Act is the levels of bureaucracy that are envisioned in the regulation. The AI Act talks about certification, it talks about notified bodies, it talks about conformity assessments. I think that all that additional bureaucracy is may not be the most efficient model for smart regulation in the AI space. I think that when you're dealing with something as dynamic and as fast-moving as AI, you should have leaner regulation that is more, perhaps more dynamic. I think that the current version of the AI Act was really a missed opportunity to experiment with a leaner regulatory model without all those notified bodies and conformity assessments being carried out. And my fear is that with all that layers of bureaucracy, what will happen is that the position of dominant firms will be cemented, because regulations, while costly for dominant firms, they are even more costly for startups and entrants. So those are just my opinions on the GDPR as well as the AI Act, and I'm happy to hear if anyone else has any views.
Yeah, I think you have a very fair point to be cautious and be worried about the fact that the regulation, the AI Act, can be used to hinder innovation, and I think that's a fair point. But I think you made your point a bit too strong about bureaucracy. I do not think that adding new bodies to implement this act will be bureaucratic or will be unnecessary. I do think they're necessary. They're just necessary evils. But they make sure that the act is being implemented now and then applied later. And especially in a field or an area which has long benefited from a regulatory gap, especially in these digital and technological markets which evolve so fast, it's necessary to set up some limits and to regulate at least something. And these bodies, I think, won't be hindering innovation. I think they will make sure that innovation can happen, but within safe limits. Furthermore, the Act also provides for actually support for innovation. There's provisions about regulatory sandbox schemes, there's digital hubs, there's testing facilities, and there's also a reduce of regulatory burdens for startups. So I actually think the opposite of what you say. But more about the AI Act in general. As it now stands, it prohibits certain AI practices from violating EU fundamental rights, and that includes competition rules and competition law. But what I find interesting is if we could go a step further, if we could go back further in time, actually, and what if we can prohibit algorithms from engaging in competition law violations at the root from the start? So a good question to ask ourselves could be, say that we can send algorithms to law school or to work for DG Comp, what would we expect them to do? How would we want them to act? And what I'm referring to here is something that is called regulation by design. And that comes down to actually programming antitrust law directly into algorithms. So if we can make competition rules specific and detailed enough, we can actually oblige companies or developers to write competition rules in a language that artificial intelligence and computers can understand. So this can be a list of instructions that is then run as a trial and error experiment. Of course, I have no interest in putting myself and you all out of a job. I think legal practitioners are necessary to interpret rules and principles that have different meaning and words and change over time. And I admit that this can contrast with the staticness or the stiffness that computer language is. And perhaps, I don't have a technical background, perhaps this is not possible now, but I think it's worth mentioning the fact that the whole area of machine learning and AI is about making the unprogrammable programmable. And so what's now impossible to program may not be impossible to program in the next 5, 10, 50 years. And so I expect AI to be able to develop in the next years, and that should be something that we should support. And I hope there's something that can happen. At the same time, I'm also learned in law, so I know the risks and regulations. So I think it's important to flag that this should happen within a safe environment. So that we shouldn't end up in a science fiction scenario that G.R. Rong already mentioned. So this testing phase, for instance, could happen in circumstances similar to laboratoria, like we would do for chemical or new pharmaceutical medicines, for instance.
So if we were to summarize our views on this matter, I think the middle ground for us would be to use regulatory sandboxes to monitor the safe development of AI systems and to make sure that it develops at a rate that's so fast that we can't really keep up. If we have these sandboxes, we're at least a few steps closer to realizing the actual goal and being able to regulate at the same time as technology develops.
Thank you so much. This was indeed a very interesting debate. I don't think we have much time left, but if you want to keep your replies a bit shorter, I would like to ask you a bit of a more practical question, so you can also give your final remarks on it. So my question will be actually about which theory of harm should we prioritize in this context, and how this should be addressed by competition authorities.
So maybe I can give a try to answer this question. I think that the theory of harm, or the type of conduct that we should really prioritize, is unilateral conduct, meaning abuses of dominance. Because I think that even though a lot has been written about how AI can enhance or facilitate the prospect of collusion and cartel arrangement between firms, the existing tools that competition regulators currently have, such as looking at information flows between companies, they will still be able to apply to collusion, which is facilitated by AI. You can look at the inputs that are being relied upon for the algorithms which are carrying out infringing conduct. However, I don't think that the same can be said for anti-competitive abuses of dominance, because today when we talk about abuse of dominance, the main tool that we have is looking at internal emails, internal presentation slides, and trying to understand what the firm was trying to achieve when engaging in, let's say, a exclusivity clause or something like that. But in the future, where there is a artificial intelligence algorithm in place making the decisions, then we don't have resort to those same tools. Because of the way that artificial intelligence models make their decisions, they don't explain themselves to you. So I think that in terms of urgency, in terms of developing the right tools to detect which kinds of anti-competitive harms, theories of harm, I think a priority should be placed on abuse of dominance rather than cartel and collusion agreements.
Well, I actually think the opposite, if I may. I think we detect very few infringements in competition law in terms of collusion. And while I do not know the detection rate of abuse of dominance per se, I do know that there was a study of the OECD, for instance, that said that 80% of cartels that we detect, that were detected by the Commission, they came from reactive processes. So that means leniency applications or immunity applications. And I think that says a lot about the area, about the practice of the Commission. To be able to evolve with the market, the Commission or the competition authorities in general need similar munition, let's say, to deal with anti-competitive behavior that as the companies that perform this behavior. And I think there's an extreme concern, especially for collusion by algorithms, again. So pricing algorithms, like I said before, they use price as an input, and then they apply computer program to it, and then eventually price comes out as an output again. And a real concern that was also already flagged by Bann is actually tested collusion. And that actually happens when companies use similar algorithms that reduce uncertainty in the market. And eventually it will become easier to predict others' reactions and the dominant strategy of another company. And this happens automatically and without any communication. And that's the real issue. I'm not sure how the Commission can keep up if there's no communication, if it's all happening automatically without there being any intervention. So I think the prioritization in this field should be on collusion, and especially by algorithms. And this could start by trying to better understand what happens behind these algorithms and how it affects competition in real life.
Thank you so much. Thank you both, Rong and Emilie, for sharing your perspectives and your contributions today. Sadly, I'm sorry, but the time is limited. So although this debate could continue on, I'm sure of that, I would like now to start the Q&A part, so the speakers can take questions from the audience here in person and offline. So actually, I see that we already have a question from the chat that we have online, which is from Adam Salisbury, and it's about artificial intelligence and liability. So,
hi, everyone. I have a question. So who should be responsible when AI does something unintended? And should AI have a separate legal personality?
Okay, I'd like to answer that question.
Sure.
So, it's true that the potential that AI would commit something that was unintended or commit some form of harm to the public, it's something that might happen. Now, before going into this legal personality topic, AI is capable, some forms of AI are capable of independent development. They can learn from data sets and improve, and they can even develop new improved AI systems that were not part of the seed program. And for AI can, AI systems are often like black boxes. So we give it a set of inputs, and we say we want this output, but we don't know what happens in the middle. How it arrives to its output is not very clear, and actually there was a really funny example that Elon Musk once gave. He said if you tell an artificial intelligence system to optimize happiness, it's going to think, oh, happiness is a combination of serotonin and dopamine, so it will bring us all and inject us with serotonin and dopamine, and that's how it optimizes happiness. So the reality of this is that it does what we ask it to do, but it might not give us what we want. And that is something that we have to take into account. And of course, there may be harms that result. So now, if we want to look at the question of legal liability, we need to break it down. What form of liability are we looking at? And this is where the idea of legal personality is really important. So I believe that prior to, for example, corporations and companies, laws in general were centered around the natural person, and there were different laws that regulate our acts as human beings, from criminal to civil. There were so many different forms. And then we saw the emergence of a new body, and that is a company. And then we added a legal personality and limited liability. And you have different forms of law that come into play, including intellectual property, including competition law. And we sort of picked out the relevant things, and we removed the irrelevant things, like giving it a political personality to vote, or if it commits a crime, we don't really put the company in jail. So there are things that are irrelevant, and we took them out. So if we think of AI as a new phenomenon that is similar to the idea of a corporation, then maybe we need to look at several forms of laws in order to be able to properly address the emergence of AI. And AI is not just a machine, because as we've said, there are 3 different levels of artificial intelligence, and one of them, artificial superintelligence, exceeds human intelligence, even in the only thing that we have, emotional intelligence. So that if it exceeds in every single sphere, then maybe we need to consider the idea of a legal personality. And perhaps this is where civil law comes into play. I've read that some countries were thinking of using tort law regimes to manage certain harms that could arise from artificial intelligence. And this is where I feel the most clear example would be self-driving cars. So let's say a car is programmed to in a certain way, and it needs to take you through the shortest path to get to a certain destination. If there was a person in front of you and the fastest way is to run over that person and go, will it do that? Now, of course, I'm exaggerating, because the reality of it is that self-driving cars are much safer than any human being driving a car. But these are things to consider. If a mistake was made, who's at fault? Is it the car itself? Is it the programmer? Is it the operator? And I think the AI Act imposes strict liability on high-risk artificial intelligence, on the operator of such high-risk artificial intelligence. And maybe the better way to do this would be to introduce a form of insurance policy that people have to, for example, there's mandatory insurance for AI systems that are high risk, and that way you can sort of limit liabilities, because you don't want to, again, you don't want to play a lot with the market and hinder the innovative aspect, people would stop creating, or if it was going to get back to them, or people would not buy or invest in artificial intelligence if it was going to be very high risk for them. So these are things that we need to consider. Maybe legal personality is not a bad thing, because again, ASI systems can have a brain and they can think for themselves. Wasn't it Facebook that created robots and they left them to speak for a bit, and then they created their own language and they panicked and they shut them down? So it is a possibility that things could get out of control. So perhaps, it's an understatement, but perhaps if different forms of law, different regulations come into play, and discussions with competition authorities, with different forms of regulation authorities, really, to make sure that there are no clashes and that they're all developing laws in a certain way. And again, the regulatory sandboxes are really a really good way to stay on track, because we don't want the law to be 10,000 steps behind with AI, because technology really does develop at a very fast pace. I hope I answered your question.
You did. Thanks very much.
Thank you so much for your question and for your reply, Bann. I'm not sure if we have any question from the audience here in Brussels. Yeah, sure.
So thank you. I have to say, I did my PhD on big data and competition law, so you manage well the topic on AI and data. To answer your question, both Jai and Bann, you're right on the fact that data is power and data is not power. It's on case-by-case basis. But you have to look at just 4 things. I will be short. First, the volume, the variety, the velocity, and the value of data. If you look at the merger, for example, between Google and Waze, one of the reasons of the merger is because Waze has velocity of data and Google Maps didn't have this velocity of data. So yes, data was important for the case here. But you have also the scarcity of data and whether the data are replicable or not. As far to you answer correctly about the fact on responsibility, and you should read the book from AI and the Law from Professor Abbott, and it's very interesting because actually we don't need more accountability for an AI, because it's like a human, an employee at the end of the day. So if an AI is doing a mistake, the company should be responsible like an employee is doing a mistake at the end of the day. It's a brand. But my question now is, you mentioned data and AI, and I'm struggling with this question since my PhD. I finished it, but I'm struggling. And the same is for collusion and anti-competitive practice. We know that we need data to train an AI, and we know that data is important to the analysis, but the data here, how do you assess which data is anti-competitive or not? Namely, if you want to collude, you can do collusion by algorithm, but you collude on data here. And which data is anti-competitive? We know that it's on, for example, price. If you try to look at price,
I'm sorry, but sorry to interrupt. But if you can just summarize
the summarize is look at data here, but how do you assess that the data that we look at for the anti-competitive practice or the collusion is anti-competitive or not? It's a tricky question.
Do you want to all try to answer?
I think we all try to answer. I can try to answer the question as I understand it. So as I understand the question, it is about what kinds of data should we look at when we are trying to determine whether or not a firm has carried out anti-competitive collusion. Is that how? I think that's right. So I think that that really gets the regulatory approach a bit backwards, right? We shouldn't look at firms and then determine whether or not they conducted anti-competitive conduct based on what kind of data that they have, but rather we should have some sort of basis for commencing an investigation into whether or not they have colluded or not. So for example, we would see whether or not there's any permanence in price arrangements despite changes in cost over time. And then from there, if that suggests that there was price fixing, then we'll look at price data. If we are talking about terms and conditions which appear to have been standardized over time when in an ideal competitive market, those terms and conditions could have been more helpful to the consumer, then we would look at terms and conditions which are being, whether or not terms and conditions are being stultified by the intervention of AI. Yeah, so that's my answer. Maybe anyone else has an answer?
I agree with you. I think the approach should be, as you said, maybe we can consider as well like how they approach price discrimination. And so here really personal data matters as well, the ability to personalize and to profile someone and then change prices for them depending on their location, depending on their general preferences. Maybe that also matters in considering data power. Do you have...
Yeah, I think I'm not entirely sure if I completely understand, but I try to give an answer. I think the main issue with trying to find anti-competitive practice is also finding the intent or the proof that this has happened, and this means that a lot of documents have to be reviewed and have to be assessed. And I think one of the things I read when I was preparing for today was another tool, for instance, that can be used to help with this is that competition authorities either make or use off the shelf natural language processing tools. So they can screen and review a lot of internal documents that contain different types of data, but because the data today doesn't just come from an email or a written letter addressed that says, I want to collude with you, but it can come from phones, emails, websites, pictures, cookies, audio files, and that makes the pile of data just bigger and more diverse. And so if we, for instance, could develop a natural language process tool, then this tool can be trained to identify automatically like illegal intentions within those documents so that it's easier and quicker. So I hope that answers your question a bit.
Yeah, thank you so much, and I hope this answered your question. I see that we also have a question from the audience online, and this is from Emmanuel, and it is on the topic of AI and IP law. So Emmanuel, if you want to ask your question. I think you're muted now. No, yeah.
Hi everyone, I have one question. Are there areas of IP law which policymakers should consider when determining how to promote AI competition and innovation?
It's yours.
I think this question is yours, dear Rong. We cannot deny.
All right, okay. So thank you for the very interesting question. So in my opening speech, I talked about how intellectual property rights in regards to shared data has to be clarified in the future for a more legal clarity in the area. However, I think that another area which is very important, in fact, probably more important, is having to do with copyright laws, in particular the rights of people to carry out text and data mining to train and build up their AI. I think that the issue here is very important because if we're talking about competition, even though big firms have access to large amounts of proprietary data, small firms probably do not, and so they would rely on online sources and other kinds of data which they can scrape through text and data mining. And here, I think that there's really a divergence in copyright laws internationally. As I understand it, the EU Copyright Directive would provide for a general exception to copyright laws for text and data mining, but the exception is only going to be limited to non-commercial applications. In Singapore, we have actually taken a different approach in our recent amendments to the Copyright Act. What we have done is that computational data analysis, if information is data mined in text, if text and data are mined for computational data analysis, if that is the ultimate purpose of that data, then there is no infringement of copyright in that regard, and that is regardless of whether or not the ultimate AI application is for commercial or non-commercial users. And this is really a very pro-AI, pro-innovation approach that has been taken in my home jurisdiction. And they really take it seriously because in the Act itself, the new Copyright Act, it says that it is not possible to exclude this right by private contract. So even if you made a provision in a contract to that effect that you cannot build a commercial AI, that provision would be void under the Copyright Act. So I think that the divergence really shows is really interesting, and we should really think about whether or not the which approach would be more favorable to innovation while also respecting the IP rights of copyright holders. Yeah, and I really just want to hammer home the point, which is that the right to carry out text and data mining is more important for small companies than large companies. And if we want to create a more competitive economy, we should really look at ways in which smaller companies can compete given the data disparity that we have discussed today.
Thank you so much, you're wrong, and I hope this replied to your question, Emmanuel. I would like to turn the question to the public here, so if you have any further questions now, yeah.
Do you think that there might be a problem of fairness with the use of digital investigative tools in competition enforcement?
Since the question is about tools, I'll try to answer your questions. I think it's a very fair question, because the right to a fair trial is of course embedded in the Charter of Fundamental Rights, so it's crucial that this should be respected, and I agree, it's something that we should look out for. I think the concern stems from the problem of an imbalance of information, so that the investigator and the enforcers, the Commission or the other competition authorities, have more information than the company, especially if they use sophisticated new tools to detect this and gather information very quickly. I think there are also ways to mitigate this. So whilst I recognize the problem, I think there's also ways that we can look at it that make the risk lower. For instance, we can agree on the fact that the Commission can only use these tools to detect and monitor. So this means that those tools are only used at the beginning of an investigation, and they're not actually used to build a case against the company. But it could also, for instance, be in a way that the legal standard is set higher. For instance, say that when a market, then there's suspicion of collusion or of an abuse of dominance, but there's no actual harm that we can already measure in the traditional competition terms, then maybe we can say that that detection of anti-competitive behavior or practice by an artificial intelligence machine can actually be a legal standard that has to be met. So that makes it actually, it makes it better for the companies, because it doesn't always mean that they eventually can be sued. If we decide to use those, the evidence that's been gathered by those tools, we can, for instance, agree on the fact that they can only be used as supporting evidence, which would mean for the future that we have to review guidelines or issue guidelines about this and about what types of evidence can be used and admitted. And that the Commission should also be prepared to disclose this. They should be prepared to disclose what has happened. And I think that is the real factor that can mitigate this, is maybe we can agree on the fact that obviously not all the data that's been gathered in an investigation should be shared with the world, but the Commission could, or competition authorities, could make publicly available the processes and the machines and the mechanisms that are used behind the scenes. So that would come down to revealing how the competition decision-making has happened. And in that sense, the competition authority or commission would actually provide transparency. And whilst I recognize the importance of the right to a fair trial, I think the principle of transparency is also essential to the EU. So we could balance those.
Thank you so much, Emilie. I think that unless there are any further questions, we can now finalize. Oh, there are one more question, I think.
You have to keep your mask on.
Yeah, if I'm allowed to also ask a question myself, there is a phrase that we often see in public communication from DG competition. It's compliance by design or by programming. So basically, the argument behind it is that a company should not hide behind the automatic workings of software or a program or a bot or whatever, algorithm you produce. You cannot actually say, it's the algorithm, it's not me, I'm not responsible. It's part of the conversation we were having a while ago. And the immediate or the intuitive way to go about it is for an enforcer to say, oh no, it doesn't matter. You need to bake compliance into the software and everybody's happy. Now, some of the things that you just debated point to the limitation, to a limit to this logic. Am I wrong?
No, you're not wrong. This is something that's true. The idea of compliance by design is actually a really good idea, and I was thinking before, I was saying the GDPR in itself, the way it approaches things, it doesn't tell you exactly what to do. It tells you we want this, comply with it, and however way you choose to achieve it, it leaves it open. And I think that's very important, and it allows for such innovations to come out, such techniques to be used and developed in order to comply in new ways. And I think that this compliance by design could work, possibly. But again, some forms of algorithm self-improve or self-develop. And since this whole concept of black boxes is an issue, it's not always the case that we can't really go into the algorithm, revise the input, see what went wrong, but it might happen. And so it is these cases that we need to consider. Maybe there should be a different approach to them. This is my opinion. Janet, do any of you have any opinion on it?
I just have one quick thought on the idea of compliance by design. I think that is a really good mindset shift in terms of businesses and how they operate in the economy. But I also don't think that compliance by design is going to be very achievable in every context, because say when you create a new product that is based on artificial intelligence in some way, then initially when you design the product, you may seek to comply with all existing regulations. However, future regulations may come by which amend the previous regulation, and those kind of changes can be quite radical. For example, the introduction of the GDPR was really a revolutionary change in terms of technology law. So how do you... so I think that the regulators really have to balance between the... still have to think about the regulatory costs, even if companies adopt the attitude of compliance by design.
Yeah, I quite agree. I think if we assume that compliance by design is going to be applied all over the world and that's the standard, and we have excellent enforcement by the tools that I proposed, then we could even assume that or conclude that ex ante regulation of other fields, that like the GDPR, like the AI Act in general, that it's not necessary, because we will have 100% compliance. So I think it's, like Rong said, a really interesting mindset and something that we have to keep in mind and also look forward to in the next 10 years. So thank you for your question.
So I don't think we have time for one last question, so I'm just gonna conclude this panel. Thank you so much to the audience for your very relevant questions, and thank you especially to the speakers for sharing your contributions with us today.